Good morning, everybody, all across the fruited plain of California. I hope you're having a great Saturday morning, and hope the weather is as beautiful for you as it is for me here in Auburn, California this morning. This is, as Ann mentioned, a presentation of the Golden State Manufactured Homeowners Education Fund. This is a nonprofit entity that was formed by GSMOL members and others about a decade ago that allows us to perform essentially nonprofit and activities under the guise of a charitable entity. GSMOL is what's called a 501c4 organization. A C4 organization under the Internal Revenue Code allows that entity to participate in legislative activities such as lobbying or participation in initiative or political candidate campaigns. And an entity that gets to do that has limited nonprofit benefits, including that any kind of donation made to GSMOL as a C4 is not a write-off for the person. Contrary to that, the Ed Fund is a 501c3 organization, which means it's charitable, formed for nonprofit education or charitable purposes. And anybody who donates $1 to the Ed Fund, as we call it, can get a tax deduction for any such money that's donated. So these kinds of town halls are put on at no charge, obviously, to anybody. But we always want you to remember who the Ed Fund is, how it works, and that it depends upon grants or donations from residents, which again, you can get a tax write-off for. So we encourage you to check out the website and donate if your heart leads you to do that. So this is a Saturday morning session. We've had a few of these during the week, and I'm on the board of directors for the Education Fund, and it was suggested by one of our members that we should really change these meetings up and have not only weekday meetings, but weekends so that folks at work are not otherwise available, maybe on a Friday morning or afternoon can attend. So we are hopeful that we have an audience today that might include some of those folks. I think that the best way to proceed today over the next couple of hours is to do what I'm going to call a 3-act play. Act 1 is going to be me giving a summary of our current legislation that GSMOL is sponsoring and answering a couple of questions related to that legislation that we've received here in advance. Act 2 is going to be me giving an update on some COVID-19 issues like liability waiver for Clubhouse and service reduction issues as we begin to see county and local and state health orders changing and allowing facilities to reopen. And then Act 3 would be me going through some general questions that we've received in advance, and then opening up to any questions that we have time for here today from the folks that are online. And we're going to be very, very heavy in terms of allocating time to questions today. My presentation is not going to be incredibly lengthy. Okay, so with that, we'll go ahead and launch into Act 1, which is a legislative summary. Now we have 3 important bills this year that we're tracking that GSMOL, the C4 organization that most of you are probably members of, thank you very much for that, is sponsoring. The first that I wanted to talk about briefly is SB 64 by Senator Connie Leyva, and that is COVID-19 related and provides most specifically that if a resident during the pandemic or state of emergency receives a 7-day notice to remedy some sort of rules violation or code violation, that they be allowed extra time to do that if they allege hardship due to COVID-19. In other words, I don't have the funds to do this because I've lost my job because of the pandemic, or I need to hire a contractor to fix my dented awning support, but I can't find one because of the pandemic conditions. The key here is that we're not talking about a delay for health and safety issues. Of course, the opposition in the initial hearings talking about, well, this is going to hurt mobile home park residents because you're going to have somebody who's a hoarder and they got boxes and garbage and debris all over their space. And we give them a 7-day notice to clean up and they say, I can't clean up my space because of COVID-19. And so all the residents in the park suffer. Well, that's not what the bill is talking about. The bill specifically in that instance would say that if it's a health and safety issue, if it's a nuisance, specifically if it's a fire hazard, anything that HCD would enforce as an imminent hazard, all of those do not allow anybody to get an extension, whether for COVID-19 or not. So that really is sort of I think a red herring that's being thrown in by the opposition. The bill is really, again, designed so that if somebody gets a notice that says you have to replace the carpeting on your steps or fix that dented awning support, or you have to do something else that's going to require landscapers or contractors to be hired, that you can request additional time to complete that, not exceeding 12 months, depending again upon the kind of issue that's involved and how long it might take to find somebody. So SB 64 by Senator Leyva, our chairperson for the Senate Select Mobile Home Committee in California, extends COVID-19 rent protections to some of the other specific issues related to the mobile home residency law. And that bill has had its first hearing and is working its way through the Senate side. Two more bills I want to talk about and answer a couple of questions related to those. The first one is a bill that we've been talking about for some time and finally being able to hopefully do something about it. And it relates to water, specifically the issue of a park that is sub-metering residents for their water usage by installing a separate water meter, which the park is allowed to do, and providing a notice to them that they will now be billed for water as a separate line item on their rent bills. And when those bills come, there's a couple different components. There's what's called a volumetric charge, which is the charge per cubic centimeter feet of water used that the resident is to pay, again, according to the water that they actually use, as measured by the water meter. And then there are some fixed charges, some recurring fixed charges that also relate to the water. And that would include something that's called a ready-to-serve charge or a customer charge. There could be taxes or other typically minor charges that were related to the provision of water. The concern here is twofold with respect to these recurring charges, because we've got already law that talks about utility rates need to be posted and residents need to understand the rates that they're paying for any utility. This bill will strengthen that, but most specifically, it goes to two evils, as I will call them, that we have seen with respect to water sub-billing over the years. Number one, that the park owner is simply making up a charge. They just make up what they call a customer charge or some kind of service fee. And it's not a charge that is charged to them by the water provider, or which has any real basis in fact in terms of the water charge being made. So the bill provides that they cannot charge any kind of a fixed customer charge unless the water provider charges it to them being the park owner. The second issue is a park owner in many cases will take the customer charge, let's say it's $25, and they'll replicate it through the entire park. So if on the master meter they paid a charge of $100 or $50 or $25, they would turn around and charge that same charge to every single space in the park. This bill is going to prevent that and provide that when they pass through any of the fixed charges, they have to be passed through on a proportional basis and divided amongst all of the spaces in the park that are receiving water via a sub-meter. So those are the two issues. Now we've got some very recent amendments that have been submitted by GSMOL based upon the fact that when we originally drafted the language, and I know I didn't realize that just 3 years ago, the California legislature had actually enacted water submetering protections for multi-residential buildings, essentially apartment buildings. And that was in a bill called SB 7 that became effective in January of 2017. And what we've done now is we've basically grafted into our bill the same sequence and language from SB 7, which passed the legislature, actually 4 years ago now, so that we're not reinventing the wheel. And the language allows the resident to be charged for the volume of water used. It specifically allows them to be charged a customer service charge, but it has to be proportional, divided amongst all of the units. And it allows the park owner to recoup billing and administrative costs. And there's a schedule for how that's figured out. In that way, the park owner is being fairly compensated for the time and effort that is required to submeter the water, to bill it, to read the meters, to create the billing, and to bill the homeowners. But the end result of this, I think, is clearly going to be that if customer charges aren't passed through to every single person and replicated to every space, and instead of what's typically going to be a lower billing or administrative cost on a fixed schedule as determined by the statute is allowed, the end result is going to be the costs are going to go down. Because right now we have some parks where residents are paying $40 a month or more for a customer service charge, basically for their meter to be read and the meter to be maintained. And in our view, that's simply not reasonable. And according to SB 7, it's not reasonable. So what AB 1061, our new bill here, is going to do is provide the same kind of protections for mobile home residents that tenants in multi-residential buildings have under what was passed 4 years ago. So that's AB 1061 that I know you're going to want to track. The final and third bill I wanted to give an update on is AB 861. AB 861 by Assembly Member Bennett is the bill that basically says, and it's based upon an existing section of the mobile home residency law that says that park management and its employees must follow all of the rules and regulations of the park to the same extent that the homeowners have to follow them, with very minor exceptions. This bill, which addresses the issue of subleasing, says that if the park owner is subleasing homes in the park, they cannot enforce a rule against the homeowner that denies the homeowners the ability to sublease. And the idea is, here, what's good for the goose is good for the gander. If the park has a rule that says homeowners can't sublease, they shouldn't be able to sublease. If the park owner wants to sublease, then they need to change the rule, amend the rule to allow homeowners to sublease also. And this will expand the ability of homeowners to sublease in those parks where the park owner rents homes beyond what's allowed now in the mobile home residency law. In the MRL, we have a limited subleasing ability under 798.23.5, and that's limited to medical emergencies and a 12-month maximum period. Under this bill, there would be no maximum period and no requirement of medical exigent circumstances like that. Again, it would depend upon what the park rule is. So one of the questions that we received, which is a very good question, is if AB 861 passes and park owners can no longer rent out the units, what will happen to our neighbors who are renting? And we know that there are some areas where there are fairly larger numbers of renters, pure renters in the parks. The answer to that question is AB 861 does not prohibit renting or subleasing or mandate it one way or the other. All it says is if the park rule says that the homeowners can't sublease, then the park owner can't sublease. That's all it says. And subleasing by the park owner includes renting out homes that the park owner owns. So you see, this question is presuming that 861 is going to say park owners can't rent homes anymore, but that's not true. Again, all it says is park owners can't rent homes if the homeowners are not allowed to rent. So hopefully that clears that up. And that's the legislative update that I wanted to give to you today. Act 2, Part 2, COVID-related issues. And as things change on the COVID-19 front here, I know I just got my vaccine this past week. A lot of you may have already been vaccinated or have that planned. We've got a lot of penetration with vaccines now. Through whatever you want to attribute it to, we have declining positivity rates. We have changing tier colors in the various counties. And so we've got different conditions than we had a year ago, certainly. And in some cases, these conditions seem to change very rapidly. I'd say by the day or the week now. Back last year, I think they were changing almost every hour some days. But the issue now is, as conditions are and restrictions are lessening and facilities are reopening, how do we manage that? And how does that sort of interface with the rights that homeowners have under the mobile home residency law and under their rental agreements? Under the mobile home residency law, 798.24 provides that common area facilities, and that includes clubhouses, swimming pools, tennis courts, hot tubs, laundry rooms, anything that allows for the common usage of the residence, those must be open and available at all reasonable hours. So we have a couple of issues that I think are on everybody's mind now when it comes to the virus. One of those is a release and liability waiver issue. Many parks are requiring that residents sign a written document similar to this that is entitled Release and Liability Waiver. And it's essentially describing the pandemic, the unique circumstances that we've been living under for over this past year, that the park owner didn't cause it. They are dealing with it just as much as any of us are. And they have to abide by whatever county health orders are in place or state directives, emergency declarations that would restrict the ability to have gatherings in close indoor spaces. And so I think we begin with the premise that it's not unreasonable for the park to say, we got to close the facilities if the local government says we have to close. And I think most of us recognized that had to happen a year ago. As conditions change, we have a different sort of paradigm coming into play, though, because now the issue is, what does the county allow or what doesn't it allow? And first, let me talk about that and then kind of come back to the issue of the waiver. So the mobile home residency law says that rental agreements are to describe the amenities that are available to the residents. It also indicates, as I mentioned, that common area facilities need to be open at reasonable hours. The question that we're facing now is, when county or local health orders change and allow reopening, what is the park owner's responsibility? And I think clearly with changed conditions, there's a changed responsibility, because it wouldn't be fair and it wouldn't be in compliance with the MRL for a park owner to say, we're just going to keep them closed until every single vestige of the virus is gone and the world returns to normal, completely normal. That would not be reasonable. And would, I think, subject the park owner to a claim for what's called a service reduction. A service reduction is something that's described in a number of local rent stabilization ordinances. and it refers to the situation where the park takes away an amenity, and the rent is not reduced accordingly, because you have to think about the amenities, the sum total of what a resident is paying rent for, as sort of like a bundle of sticks. You know, the right to occupy your home, the right to landscape your space, the right to use common areas, drive your vehicles on the park streets, whatever that is. If you take away some of those sticks, if you close common area facilities, then in theory, you've reduced services that rent is being paid for, and you may be liable then to have to reduce the rent by some amount of money that would comprise the value of the service that's been removed. That's the theory of a service reduction, and there are some RSO ordinances locally that allow residents to actually make those claims to offset rent increases when hearings are brought under the RSO provisions. So in this case, with COVID-19, I think it's clear that as conditions change, the park owner has to change its policies with them. And if the county health order says you can reopen the clubhouse, I believe it's reasonable and in compliance with the MRL that the park owner must reopen the facilities on whatever limitations the county requires. In some cases, for example, with the swimming pool, there could be limitations as to how many people you can have in the pool per square yard of water. And you may have to monitor and regulate that if you're management, and make sure that no more than 10 people or 5 people or 3 people use the pool at one time, according to how big the pool is. Same thing with a hot tub. Same thing with the clubhouse. We're now going to have a maximum occupancy. Everybody's going to have to wear a mask. Everybody's going to have to socially distance. We're not going to have everybody, packed into closed spaces. We all know all about this. We've been watching all this stuff, for months. And the question then becomes, what if the park owner doesn't do that? What if the park owner says, "Nah, this is going to cost too much money and too much time. We don't want to have to sanitize the entire clubhouse every day to wipe down, surfaces. We don't want to have to hire extra people to be pool monitors. Our management team is not, hired for that purpose." Well, I would just say to you, Mr. Park Owner, that you're a business. You're regulated like all the other businesses under the local county orders, as businesses are described in those orders. And if you're allowed to reopen, then you have an obligation to reopen, and you need to train your staff and put into place whatever it is that's required to allow that limited opening to happen. Now, we have an interesting decision that's been rendered on this, and it's referred to in a new bulletin that we posted on the GSMWL website. It was pointed out to me by the residents that I was actually inaccurate. It's not from the city of Hayward. It's from the city of San Leandro, which is right next door to Hayward. But in that park, which is owned by a very high profile park owner, the park facilities were closed probably right around the same time that everybody closed down in mid-March of 2020. By somewhere in early September of 2020, the county of Alameda, where this park was located, was allowing certain facilities to reopen, and that included a swimming pool. The park owner elected not to open the pool. After the fact, they alleged that it would just be too expensive to do that, and also there were wildfires at the time. There was all kinds of smoke in the air, and it would have been unsafe to open the pool anyway. And so what they did is they basically just kept it closed. It went through the month of October. We get to November 1st, the pool basically shuts down anyway because they don't heat it anymore. They bring the furniture in for winter. The residents claim that because the park didn't reopen the pool when they could have, that there was a service reduction. A hearing officer or a rent administrator in the city agreed with the residents and awarded a rent reduction of a couple of dollars for the lost time that the pool was not available during a period of time between September and October of 2020. The park owner appealed, and a An independent hearing officer was appointed. It's a hearing officer that I've been in front of before. The same hearing officer who decided two very important rent cases in Carol Brinkman's Park in San Juan Capistrano. And he had a full half-day hearing, heard all the facts and evidence, and issued a very detailed 16-page opinion, actually. And the opinion, in essence, found that the park owner could have opened the pool, chose not to do so, didn't show enough justification as to why they kept it fully closed, and therefore found a service reduction and ordered that the residents be given a one-time rebate equal to 1.5% of their monthly rent. It's my understanding the park owner intends to appeal that decision. In the decision, there's a civil code section that was referenced that's important for us to consider. As part of SB 91, which was just signed into law as an emergency measure by the governor just this last January, 3 months ago, there's a subsection that says that a landlord who temporarily makes unavailable a service or amenity in compliance with federal, state, or local public health orders or guidelines shall not be considered in violation of a rental agreement, nor to have reduced services under a rent ordinance. Basically saying kind of what I just went through, which is if the county health order or a state emergency declaration says you got to close, then you got to close. And you're not liable for service reductions by following the government orders. However, in this decision, the hearing officer found that the government orders had changed, had allowed the pool to reopen, and the park owner chose not to do that. So this is not a decision that has a force of precedent. It's an administrative decision. It's not a court case, but decided by a very competent hearing officer, a former city attorney, actually, and a gentleman who knows a lot about mobile home law. I think it's a very interesting decision and one that provides some guidance for us all. So related and coming back to the issue of the waivers, if a park is going to reopen the facilities, as this decision I just mentioned is saying that they should, then the question is, can they require residents to sign some kind of a written release and waiver before you enter the clubhouse? And again, this kind of a form, we've seen a number of them around the state, is, in my opinion, not unreasonable. And I think the park can require a waiver like this, provided a couple things are true. Number one, the waiver should be specifically limited to COVID-19. It cannot include anything else. It cannot excuse the park owner from not following whatever protocols are required to keep the residents as safe as possible. And in fact, if a resident signed this kind of a waiver and then the park owner, took no steps to protect anybody, the waiver wouldn't be valid anyway, because the park owner by its own conduct would have pretty much destroyed its own waiver. So I think it's reasonable on the one hand for a park owner to say, look, Mr. or Ms. Resident, we don't know everything yet, even about COVID-19. We know it's very transmissible. We know it's very contagious. We think we know a lot about how it spreads. We're not sure. I cannot, as a park owner, guarantee you that you won't get it if you come in here. There's no possible way anybody could guarantee that. It's impossible. So I need you to sign something that says you're not going to hold me responsible if we reopen the clubhouse on a limited basis and somebody who's sick comes in there and we can't control that, and then you get it. You can't sue us for that because we didn't cause it. That's kind of what the release is saying. I think in many cases, park owner insurance companies may be requiring that these be signed if they're going to keep the insurance in place, because this is a huge, very unique and brand new kind of claim that we're looking at. Frankly, I don't even know how somebody could prove this. If a resident got COVID, I don't even know how they could prove they got it by going into the clubhouse. Maybe they could, but I think it would be a tough case anyway. So I think that on the face of it, as long as the language is limited to COVID-19, limited to the period of the pandemic, essentially, then subject to whatever the language might say otherwise, I think it's probably okay. But that doesn't relieve them from their responsibility to do whatever they've got to do to keep the place safe. And the question that we got, which is a good one, a related question is, what if the park owner says every single resident in the park has to sign this release before anybody can use the facilities? Well, I think we know the answer to that. That just would not be reasonable, in my opinion. You're always going to have, what if you have a park of 400 spaces? To say that you're not going to have at least one person who thinks that the virus is a hoax, it doesn't exist, there's nothing happening, it's all made up, and therefore I'm not going to wear a mask, I'm not going to distance, I'm not going to pay any attention, and I'm certainly not going to sign a paper like this. One person with that attitude would mean that nobody could use any of the facilities. So in my opinion, and I have to say that I have not heard of any park doing this until I got this question. All of the parks that we're hearing about or learning about are saying the resident who wants to use the facility has to sign it to use it, but they're not saying everybody in the park has to sign it before I can use it. So I think that's unreasonable. I don't think they can require that at all. And if they say, we're not going to open up the gym or the pool or the clubhouse till everybody signs, to me, that's flatly unreasonable. It's an MRL violation, and they're just using COVID as an excuse. They're just saying, we don't want to clean these facilities, and we don't want to heat the pool. We're saving money by not heating the pool. We're not putting chemicals in there. We're not hiring janitorial to clean the clubhouse. Great, let's just keep it all closed up and save money. That's not going to fly, in my opinion, and that would be a service reduction. There were some other questions that we got related to this. And here's another great question, and it kind of ties into the case that I mentioned, or the decision I mentioned out of the city of San Leandro. If resident access has been closed during the pandemic, does that automatically allow space rent to be rebated? Because residents are saying, I kept paying rent at the same amount, you never reduced my rent, but all these facilities were closed for 1 month or 6 months or 12 months. I want a rent rebate. Am I entitled to one? I think that the decision I mentioned would indicate you're only going to be entitled to a rebate or a service reduction if you can prove that after county health guidelines changed, the park still did not open up the facilities. Again, folks, this isn't the park owner's fault. They had to close facilities because of a once a century pandemic. It doesn't mean that they didn't have some cost still related to maintaining those facilities. Maybe not as much cost, but they still had some cost. So I think that you're probably never going to win a case that gives you an automatic rebate. But if they say, again, well, we just don't have the employees to handle it, again, I'm not buying that argument. That's part of the job. That's part of the business. Any business could say that. But businesses are adapting, restaurants, retail, they're adapting, and they're taking steps to put those protections in place. I saw somebody popped up a question on the screen. It's a very good question that I don't have an answer for, which is, what if the park starts to say you have to have proof of vaccination in order to use the common area facilities? That is a question now that's becoming very hotly debated. The idea of vaccine passports is something that we're hearing about almost nightly on the news. Will airlines require it? Will sporting events or concerts require it to get in? Can states require it? I think that clearly government is going to have a huge problem requiring vaccine passports, because if it's government action and they require it, people who don't want to get a vaccine for religious purposes or because they have maybe some other health condition are going to say, this is discrimination. You're discriminating against me based upon my religious beliefs. And they're going to say, that discrimination under constitutional principles is not enforceable. So I think the government's going to have a real problem. Whether a private business can require it is going to be somewhat of a different matter, because you can't use discrimination the same way if there's no government action. It doesn't have the same kind of foundation for a legal claim. In my view, because we do, however, have the mobile home residency law and the section that I talked about, 798.24, and we have rental agreement language and the fact that amenities need to be described and provided, I would say that a park owner is going to have a hard time, I think, requiring a vaccine passport or proof of vaccination. I just think that, again, you're trying to make an exception that maybe swallows the rule here. And certainly if somebody said everybody's got to be vaccinated in order for anybody to use the facilities, that would be completely outrageous. But this is a developing issue, right? Frankly, it's a developing issue. We're going to have to just all stay tuned to see how things shake out with it and maybe how courts deal with it. All right, so that kind of completes what I wanted to talk about for my Act 2. And again, when we open it up for questions here in a bit, I'm happy to take any more questions related to that. Right now, and as I see questions that still keep popping up, there's no law at all right now about proof of vaccination that I know of. This is all just a developing issue. I'm not aware of a law. I'm not aware of any business or anybody yet who's requiring proof of vaccination. I think that's only going to become an issue when enough people get vaccinated to make it an issue. Right now, I can't remember what percentage of the population of California has been vaccinated, but I think it's somewhere around 30% at most. And that's increasing a lot, but until we get into the 60 or 70 percentile, it's premature. It's really a premature issue. So I have some other questions that I wanted to take that and address that were submitted in advance before we open it up to your questions. And why don't we do that? These are really great questions. Again, as Ann mentioned, during this part, since we're recording, I'm not going to identify who asked the questions, but these are all really good questions. And if you're on the call, you know who you are. So I thank you for submitting these questions, because we can all learn from them. Sometimes I learn from them. I get a question and I think, let me look into that. I got to, figure out the answer to that question. So I appreciate them all. So here's a couple of easy ones that essentially relate to basic MRL kind of foundational issues. Define the term legal tenant in terms of a mobile home contract. Does this include persons under age 18? Do adult sons and daughters require proof of employment to be a tenant? So remember that in our mobile home residency law, which is the Bible, I still have my 2019 copy from the Senate Select Committee that I use, with some of the new sections that have since been passed, inserted in. But the term tenant has a very specific legal definition for us to remember. We can throw out that word, he's a tenant, she's a tenant, but a tenant in the MRL is very specifically defined as a homeowner who has a tenancy. A homeowner is really what the key term used in the MRL, not tenant. But a homeowner is somebody who owns the home, has an interest in the mobile home structure, and is a tenant or has a tenancy agreement. And to be a tenant, you have to be park approved. You have to submit an application, show proof of income, and show a good credit rating, and then be approved for tenancy. So that's how a legal tenant is defined. People who live with the person who submits the application are what we call additional authorized occupants of the home. That would include children, whether they're adults or minors, maybe other family members or friends that are authorized to live there. Those are considered permanent guests. We do have a provision in 798.34 of the MRL that allows somebody to designate a companion, as that word is used. But they don't have tenancy rights. Only the people who apply for tenancy in the park sign a rental agreement and are park approved based upon income and credit rating are the legal tenants. If somebody wants to become a tenant, yes, they are going to have to provide proof of income or proof of employment. People under age 18 won't be tenants. They're not going to be homeowners, in other words. They're going to be additional authorized occupants. And those people do have protections under the guest provisions. Immediate family cannot be charged a guest fee. So you have minor children, even adult children living with you. They're additional occupants. They don't have to qualify to be a tenant. They don't show their income. They just sign a little sort of application form indicating who they are, what car they drive, and they're approved to be an occupant, and no fee can be charged for them. So those are some of the basics that those questions kind of call up for us. We have a question. A lady who lives in a senior community asked this question. They're now allowing new owners to move in when either spouse is 55 years old. They've moved a young family with a small child into one of the homes while the family's home is being rebuilt due to a fire. Sounds like maybe it's kind of a temporary situation. We think there could be others. They're bypassing the manager. How do we find out if we have more than 20% of underage seniors living in the park? So to kind of just briefly describe senior park regulations, what is called housing for older persons under the federal law. Adults only housing is now unconstitutional. You cannot have adults only. That's family discrimination under the 1988 federal law. So this is why we have either all age mobile home parks, what we call family parks, or we have senior parks or housing for older persons facilities. A senior park, to qualify, it must have 80% of the spaces with one person age 55 or older. The other 20% can have different ages under the federal law. That's the sort of minimum threshold. But parks are also allowed to go beyond that. They are allowed under a California Supreme Court decision to have rules that say every resident of the park has to be a certain age or older. Or they could say one person 55, everybody else age 45. Everybody has to be 55. Everybody has to be 65 in some cases. So in this series of questions, if you have one spouse 55 or older, that's okay under the federal law. But the question then becomes, what does the park rule say? I would have to examine the park rule to see, does it have its own limitation on the minimum age? If the rule is being violated, then the residents should petition to management about that. And if they see evidence that there are underage people walking around the park streets or occupying homes, then they should call that into question. Either have a meeting with the management under the MRL provisions that allow for meetings. There's a provision that allows homeowners to request a meeting under 798.53. This would be a perfect issue to request a meeting for that. The related question would be, how do we find out if we have more than 20% of underage seniors living in the park? And that final part of the question is really getting to the issue that, what if the park is allowing underage residents to the point where the 80% minimum is violated? What if you only have 79% of the spaces or less with one person 55 or older? That could end the exemption. And the danger for the park owner and the residents who want it to be a senior park is if they don't police it right, then a different agency, HUD, the Federal Department of Housing and Urban Development, could investigate and find that you're not a senior park because you don't have 80% with one person 55 or older. Therefore, you have no choice. You have to be a family park. And it's really hard to go back. As you might imagine, once you open up the floodgates and go below 80%, it's pretty hard to go back above it unless you're right there on the line. How do you find out? Well, the way HUD would investigate is they would want to see driver's licenses from all the occupants of the park and determine their age. Not sure how residents could really get to that information. That's private information. The residents could not demand that the files be all opened up. But certainly, if you put a call into HUD, it could trigger an investigation. And I don't know if the residents would like what HUD might eventually find. So it's kind of a delicate issue. I'd say I just start by talking to management about it and letting management know, you better start policing this, because we don't want the age status changing for us. Try to go through another 10 minutes or so of these questions before we open it up to you all. Had a question here about a gentleman who lives in a park where they have propane gas meters. They're sub-metered for propane. Apparently, he complained that he was being improperly charged, and the park owner's response is, well, then we'll just take you off the account. And they removed him from the account, told him, get your own propane tank, buy your own propane. You can't be part of what we otherwise provide. Can the park do that? Well, I think the answer is probably in the rental agreement. If your rental agreement says that propane will be provided, then I would say, no, they can't. And to single you out and subject you to financial prejudice by treating you differently, I think is a problem. So I would start with the rental agreement. It's an interesting question. I've never actually heard of this ever before. And I think it could only happen with something like propane, because a park could never disconnect somebody from the electric system or the gas system and say you have to buy your own electricity. That would just be absurd. There's no way that anybody could provide their own electricity. So I think there is one facet to this that is unique. And I have to really think about that more, but that's my general response. We have some questions from one of our members. If I signed a voluntary arbitration clause in my lease, can I rescind it during the term of the lease? If not, how can I get out of it when my lease comes up from renewal? For those not familiar with these kind of things, an arbitration clause says that if you have a complaint, a claim against the park, you cannot sue the park in a court of law. You have to go to some kind of arbitration. And this is a clause that's really primarily directed to what we call failure to maintain lawsuit situations, where residents get together and sue the park for what the attorneys who represent residents would call slumlord conditions. The park owner doesn't want those cases going to a jury. They want those to go to arbitration. And they would rather, avoid the risk of big jury verdicts. If you sign such a clause, you can't simply rescind it. No, I mean, it's going to be part of the lease contract. One party doesn't have the ability to just automatically rescind it by a letter. Now, a court of law might order it rescinded, but you'd have to, bring a lawsuit to have that happen. When your lease is up for renewal, you would just want to say, I'm not going to sign that clause. I'm not going to initial it, or I'm not going to sign a separate arbitration agreement. And again, residents never have to sign any kind of document once the original document you signed when you moved into the park expires. They can't make you sign lease updates or new leases or rental agreements. The way to get out of a clause like that is really based upon a legal theory. The attorneys in San Diego at the ASK law firm who represent residents in failure to maintain cases are very skilled at making legal arguments to attack these arbitration clauses. And I won't go into all that because it's pretty complicated, but there are ways to get out of it. And there are ways where courts have invalidated the arbitration clauses if the language is not constructed correctly, or if they weren't offered in a correct manner. What if you get a notice of violation to remedy something, but there's 20 people in the park doing the same thing? In this case, it was 2 trees planted close to the curb, and the management saying they're too close to the curb, you have to remove them. Well, what I've always told folks who come to me with a 7-day notice for rules violation, if they say, they told me that I could only have 1 dog. I've got 2 dogs. I've had them for 10 years. Nobody's ever said anything. And now suddenly they're saying you have to get rid of one of your dogs. Well, one argument is, well, they waived their right to enforce the rule because they did nothing for 10 years. Another argument would be, what if 50 other people in the park all have more than 1 dog and they're doing nothing to those folks? then I would argue again that the park waived its right, that the legal doctrine is a waiver. They waived their right to enforce the rule because they weren't enforcing it. And they can't just single one person out to enforce the rule. That's not fair. Um, Especially if you've got people who've relied on that. I had a client years ago who had a matched pair of dogs. They were sort of a brother-sister matched pair. He really thought they needed to stay together. He gets a notice you have to get rid of one. Like, how do you decide which dog to get rid of that you've had for years? He got a petition signed by many other brave residents of the park who said, well, we got two dogs too. And actually, when we moved in here, we weren't told you could only have one dog. We looked around and everybody had more than one dog. So we relied upon that. And that's called promissory estoppel, meaning they relied upon something to their detriment. And so you can't yank that out from underneath them like a tablecloth underneath dishes and say, sorry, we're not going to start enforcing the rule. So that's really, I think, a critical part of this question. When it comes to trees, if management just says the trees are too close to something, you got to move them, I'd be saying, well, no, you need to give me a reason. Are you telling me that the tree roots are busting up your curb? Is that the problem? Well, we can remedy that by doing what's called root abatement, where you can block off roots and you can stop the root progression and thereby stop any kind of deterioration to curbs or concrete. Lease agreement. The owner's attorney is working up a new lease agreement. Can they force me to sign it? Again, no. They can never force you to sign a new agreement once you're already a resident. That's an absolute no-no. What if this agreement has $100 per day fines for infractions? Guess what? Fines are not enforceable under the MRL. The only kind of things you could be charged for are rent, utilities, and services actually rendered. And in one provision, you can be charged if you are not landscaping your space, and the park gives you a 14-day notice. That's in Civil Code 798.36. They can give you that notice and say, if you don't pull the weeds or mow the lawn or do the landscaping, we're going to hire somebody to do it and we'll bill you. But there's no provision that allows $100 per day fines. The only time a park owner could do that is if it's a resident-owned community and it has bylaws or regulations within that community that allow that, because the MRL literally doesn't apply to that community. So that would be my response to that. It also appears from this question that this new lease is going to have different regulations or rules in it than maybe some of the other rules. Can the park have more than one set of rules? I don't think so. I don't know how on earth you'd ever enforce two different sets of rules and figure out who's subject to this set of rules and who's subject to the other set. That would be just a confused mess. So no, has to be one set of rule. Tennis court needs to be resurfaced. They're thinking about pickleball courts. But would it be a new amenity under the rent stabilization ordinance? And we don't want to build the cost to convert tennis court to pickleball. That's really a specific question for whatever your jurisdiction is. You'd want to look at your lease, rental agreement, or rent ordinance and see what it says about capital improvements, something that's brand new, as opposed to a capital replacement, which is just fixing something that already exists. We have a park that's getting sub-metered for water now and trash and sewer. Again, that's a whole process that is allowed under 798.41, which allows utilities to be broken out separate from rent. But we always have the issue of how do you determine the amount of that, especially with water. It can get dicey because the question is, how was the breakout calculated? Did you install water meters in advance of the breakout? Did you run the meters and look at a historical usage for the spaces? This question talks about rental homes and whether or not rental homes in a park would be calculated into that. And my answer would be absolutely, they're calculated in. The fact that a home is sitting in the park and it's rented doesn't mean that it shouldn't become part of the average in calculating how much of the rent dollars are water dollars. the way that I always think about it is, think about a stack of dollar bills that you pay for rent. They're all green, right? They're greenbacks. Well, we're going to color some of those blue, and we're going to call those, these are the dollars that you pay for water. And when water is submetered, all those blue dollars come out of the stack and go over here separately, and the rent needs to be decreased. Otherwise, you've got a rent increase. So I think that answers the question in terms of the rental homes. Again, they should be treated or into the calculation exactly the same as non-rental homes. Final questions that I have from one person, I'm going to try to go through quick because there's a number of them. Do residents have to sign amended rules and regulations? Very good question. The answer is no. And as a matter of fact, you don't want to sign them because, again, under the mobile home residency law, in the section that talks about how rules and regulations are amended, which is 798.25, rules and regulations, when they're amended, take effect 6 months later after the meeting that occurs, the meet and confer to discuss the new rules. 60 days later, if they're just rules about common area facilities like hours of operation or something, or immediately they take effect if somebody signs them. So you never want to sign them because then you're basically saying, I agree these rules apply to me immediately. If a park says, you don't sign these, then I'm going to evict you. Good luck, because that's an empty threat. I mean, it sounds really scary. And a lot of people might say, well, I don't want to be evicted, I better sign these. But it's a false threat. They could never enforce it in a court of law. The one twist here is this. If you have rules that are provided in this packet and they say, please sign here to confirm that you received the rules. There's nothing wrong with that, but I tell people don't even do that because I would almost have to see the language to make sure you're not agreeing that they all take effect. If you're only agreeing by signing that you've received them, that's not really an issue, but the language could be really dicey. So it's better, just don't sign anything. If they hand them to you, they mail them to you, yeah, I got them. I'm not going to sign anything. I don't need to. Can the park change rules to require the resident to list the owner or management as additional named insured on the insurance policy? Great question. In my opinion, the answer is no. Now, the park, I think, could reasonably require insurance, and I would never advise a resident not to have it. And there are some cases where people might lose a job, they might lose it at least temporarily, but I would never advise a resident to go bare if at all possible, because it's in your own best interest to have insurance. But to require that the park be named as an additional named insured is a very specific endorsement on the insurance contract. And I'm saying it's not reasonable and they can't require it based upon investigation I did some time ago, some years ago, where a local insurance broker in San Jose that was very well known told me there are companies who won't even do that. They just say, if you're, Bob and you live in the mobile home park and you want to insure your home, we're not going to write an endorsement that says your park owner is an additional named insured. We're not even going to do that. So my response is, if insurance companies won't even write it, the park owner certainly cannot require it. And also requiring certain limits, I think, is dicey. I would just say any reasonable homeowner's policy that has limitations for liability, dollar limitations for liability, and protects from fire and loss to the structure according to the value of the structure, I think that that's reasonable. Is closing all the facilities, the common area facilities at 7 p.m. reasonable? Reasonable hours, again, is the language in our MRL section that we've talked about a few times over this past hour, 798.24. So what's reasonable? I think certainly, 9 or 10 at night is reasonable. 7 p.m. may or may not be reasonable. I think maybe it's depending upon the time of year. I know that some parks will close early in the winter because it gets dark earlier. There's a senior park. They want to discourage residents from walking around in the dark, maybe getting hurt. In a very metro kind of setting, urban setting, there may be safety issues involved with people walking around the park at night. So it might very well be reasonable to say we're going to close facilities earlier in the winter. How do you get the facilities back the hours you want? Get a petition together, request a meeting with park management, again, according to the section I mentioned, 798.53. If management's not responding, maybe go to offsite management above their head or straight to the park owner about it, but indicate that we don't think it's reasonable and we want the hours to be extended. Can a park put in rules? Don't contact the park owners about your complaints. Well, they can put that in there, but that they can't regulate that. I mean, it's an unenforceable rule. You certainly have a right under the MRL to find out who your park owner is so that you can contact them directly. You can go to the HCD website. There's a Find a Park tab you can click on, put in the name of the park, and it'll tell you who the permit owner is. And sometimes that will lead you directly to the park owner, him or herself or itself. But yeah, that's one of those rules that they can write that in there 50 times if they want, but they can't stop that from happening. Hopefully, we've addressed some valuable points today, giving you some great information. Again, information is power. Knowledge is power. If you don't know your rights, how can you enforce your rights? And that's why we're here, folks. We're here to educate you, to empower you, inform you, help you to organize, to protect yourselves, and to maintain and improve your style of life.